Welcome to LexTalks Legal Topics Simplified, where we like to break down complex legal topics,
Mm.
just make them a little easier to understand for Indian law students.
Yeah, exactly.
And today we're diving deep into Article 14 of the Indian Constitution,
Ah,
the
yes.
right to equality.
The right to equality.
You might think, you know, okay,
Yeah.
equality,
Yeah.
got it.
Quite forward.
But trust me,
Oh, yeah.
there's a lot more to it than meets the eye.
Absolutely. There's so much to unpack there.
Exactly. We've got a stack of articles and legal analyses here, and our mission is to unpack what Article 14 really means in practice,
Yeah.
how it's been interpreted, applied,
Right.
and even where it gets a bit tricky.
It really is a cornerstone of Indian law, I think, and you'll find it throughout your studies, no matter what area you specialize in. It's something that you're going to come back to again and again.
Exactly. And it's not just some static rule written in a book.
Mm-hmm.
It's this living, breathing principle that's constantly evolving.
Absolutely. To really grasp its significance, we need to start by understanding what Article 14 actually says. It has two key components.
Yep.
Equality before the law
Hmm.
and equal protection of the law.
Okay, break that down for me a little bit. What does that actually mean for people in India?
Essentially, it means that everyone is treated equally under the law
Okay.
without any arbitrary discrimination. No one is above the law, and everyone is entitled to the same protection.
That sounds pretty straightforward. Where does the complexity come in?
The complexity lies in how these principles are applied in real-world situations.
Okay. Yeah.
Think about it. If everyone was treated exactly the same in every situation,
Mm-hmm.
wouldn't that actually lead to unfairness sometimes?
You got a point. Like, a small child and a grown adult obviously shouldn't be held to the same legal standards, right?
Precisely, and that's where the concept of reasonable classification comes in.
Okay.
Article 14 doesn't mandate absolute equality.
Right.
It allows the state to make special laws for certain groups of people if there's a logical and justifiable basis for doing so.
So it's not about giving special favors, but recognizing that different situations sometimes require different approaches.
Exactly. But there are rules to this. This classification can't just be random or based on whims.
Right.
It has to meet two essential conditions:
Okay.
intelligible differentia
Okay.
and rational nexus to the objective.
Okay, those sound like pretty important legal terms. Can you break those down for me?
Absolutely. Intelligible differentia simply means there has to be a clear and understandable difference between the groups being treated differently. You can't just create arbitrary categories.
So there has to be a real logical reason for treating one group differently from another.
Exactly. And then rational nexus means that the classification must have a logical connection to the objective the law is trying to achieve.
Okay.
There has to be a clear purpose behind the distinction.
So the law can't just say, we're treating these people differently just because. There has to be a reason that makes sense in the context of what the law is trying to do.
Right. It can't be arbitrary. Let's look at some examples to make this clearer. One area where this doctrine comes up is in sex-based classifications.
Interesting. Does that come up often in Indian law?
It certainly has. Think about the adultery law in India, Section 497 of the Indian Penal Code.
Okay.
Historically, this law only punished men for adultery, but not women.
Wow. That seems pretty outdated.
It was, and it was eventually struck down by the Supreme Court, but the initial justification was based on societal norms and the idea of protecting women.
I see how that reasoning might have been used,
Yeah.
but it definitely raises questions about equality under the law.
It does, and that's why this whole area of reasonable classification is so fascinating.
Yeah.
It requires us to constantly analyze and reevaluate whether the distinctions made by the law are truly justifiable in light of evolving social values and legal principles.
I'm starting to see how this can get pretty complex.
Yeah,
It's not just about reading the words of Article 14.
right.
It's about understanding how it plays out in real life.
Absolutely. Let's look at another example.
Okay.
Think about the Right to Education Act.
Okay.
This act uses classification based on financial status to provide free and compulsory education to children from economically weaker sections.
So the idea is to create a level playing field for those who might not otherwise have access to education.
Exactly. And the courts have generally upheld this type of classification because it meets the intelligible differentia and rational nexus tests.
Okay.
There's a clear difference between the groups,
Hmm.
those who can afford education and those who can't.
Right.
And this difference is directly related to the objective of promoting education for disadvantaged children.
That makes sense. It's about ensuring that everyone has a fair shot at a good education,
Yeah.
regardless of their financial background.
Exactly. And that leads us to a really important point. Sometimes treating everyone exactly the same can actually lead to unfair outcomes.
Okay.
Article 14 isn't just about formal equality, it's
Right.
about achieving substantive equality,
Yeah.
ensuring that everyone has a genuine opportunity to thrive.
This is all really eye-opening.
Yeah,
So while the core idea of Article 14 is equality, there's a lot of nuance in how it's actually applied.
absolutely. And to understand that nuance, we need to delve into another key aspect:
Good.
the historical context that shaped Article 14.
Right, because India's history is full of examples of inequality and discrimination.
Mhm.
How did that history influence the framing of Article 14?
It played a huge role. Think about the period of British rule.
Mm-hmm.
Colonial laws often reinforced existing social hierarchies and created new forms of discrimination.
So the framers of the Constitution were reacting to that legacy of inequality and trying to create a legal framework that would ensure equal rights for all citizens.
Precisely, they were acutely aware of the historical injustices that had plagued India and were determined to establish a system based on the principles of justice, liberty, equality, and fraternity.
It sounds like they were drawing inspiration from various sources. I know they looked at international documents like the Universal Declaration of Human Rights, right?
They were influenced by global legal thought, particularly the emphasis on equality and human rights that emerged in the aftermath of World War II.
So they weren't just looking inward at India's own history.
Right.
They were looking outward at global best practices, so to speak.
Exactly. And it's fascinating to see how those international influences combine with India's own unique context to shape Article 14.
Yeah.
Did you know that Article 14 was actually initially part of Article 15 in the draft Constitution?
Really? That's interesting.
It just goes to show how carefully the framers considered these ideas and how they debated and refined the language to create the most effective legal framework for ensuring equality.
So Article 14 is a product of both global ideas
Yeah.
and India's specific historical and social context.
Exactly. It's a testament to the vision and foresight of the Constitution's framers, who recognized that equality is not a static concept,
Right.
but an ongoing pursuit that requires constant vigilance and adaptation.
This is all so fascinating, but I know we've only just scratched the surface of Article 14.
Wow.
There's so much more to explore.
You're absolutely right, and the best way to truly understand it is to delve into specific cases and see how these principles have been applied in real-world situations. Are you ready to dive into some case law?
Absolutely. Bring on the case studies. All right, so we've laid the groundwork for understanding Article 14, now ready to see it in action. What are some cases that really highlight how these principles play out in real life?
Well, one case that always comes to mind is E.P. Woyappa versus State of Tamil Nadu in 1973. It's a landmark case that really shifted the way Article 14 is interpreted.
Okay, I've heard of that case, but honestly, I don't really remember the details, what was so important about it.
This case introduced the concept of non-arbitrariness as a core element of Article 14. Prior to this, the focus was mainly on reasonable classification, but in E.P. Woyappa, the Supreme Court expanded the scope of Article 14, recognizing that equality isn't just about classifications, it's about ensuring that all government actions are fair, rational, and not based on personal whims or prejudices.
So it's about moving beyond just categories and looking at the inherent fairness of the law itself.
Exactly. The court recognized that arbitrariness is inherently opposed to equality. This case had a huge impact on judicial review, giving the courts more power to strike down laws or actions that they deemed arbitrary.
Wow, that's a pretty powerful shift in legal thinking. How do they justify this change? I mean, isn't there some level of discretion needed in how laws are applied?
There is, and that's where it gets tricky. The court wasn't saying that all discretion is bad, but they emphasized that discretion can't be unfettered. It has to be exercised within the bounds of reason and fairness.
So if a law seems unfair or if it's applied in a way that seems discriminatory, even if it technically falls within the reasonable classification test, it can still be challenged.
Exactly. E.P. Woyappa essentially added another layer of protection against discrimination. It forces us to ask not just, is there a valid classification, but also, is this law being applied in a way that's arbitrary or discriminatory?
Okay, I'm starting to see how this doctrine really raises the bar for ensuring equality under the law. It's not enough for a law to just look good on paper. It has to be implemented in a way that's truly fair and just.
Right. Let's look at a specific example. The case of Oregano Chemical Industries versus Union of India, 1979, really highlights this point. In this case, the government had imposed some very harsh penalties on a company for some delayed payments under the Employees Provident Funds Act.
So it's a situation where the government had some discretion in how to apply the law.
Exactly, and the company argued that the government had acted arbitrarily and exceeded its authority.
What did the court decide?
The Supreme Court sided with the company. They ruled that while the government did have some discretion in imposing penalties, the penalties in this case were excessive and disproportionate to the offense. They were deemed arbitrary and therefore a violation of Article 14.
So even though the government technically had the power to impose those penalties, the court said, nope, you went too far. That's not fair.
Precisely, this case shows how the doctrine of non-arbitrariness acts as a check on government power. It ensures that even when discretion is allowed, it can't be used in a way that's oppressive or discriminatory.
It's amazing how one case can have such a far-reaching impact on how a fundamental right like equality is interpreted and applied.
Absolutely. And E.P. Rariappa is a perfect example of that. It really set a new standard for how we think about equality in India. It's not just about preventing overt discrimination based on things like caste, religion, or gender. It's about ensuring fairness and rationality in all government actions.
So it's about creating a system where everyone feels like they're being treated fairly and with dignity, regardless of their background or circumstances.
Exactly, and that's what makes Article 14 such a powerful and enduring principle.
Okay, so we've talked about reasonable classification and non-arbitrariness. What other key concepts do we need to understand about Article 14?
Well, no discussion of Article 14 would be complete without talking about the exceptions.
Exceptions, but wouldn't exceptions to a fundamental right like equality kind of undermine the whole point?
That's a valid concern, but it's important to remember that these exceptions aren't loopholes designed to let the government discriminate. They're carefully crafted provisions designed to address specific situations where absolute equality might not actually lead to the fairest outcome.
Okay, that makes sense. So these are situations where, for very specific reasons, it's actually okay to treat people differently.
Exactly. And there are a few different types of exceptions. For example, the law recognizes that there are inherent differences between the rights of private individuals and public officials.
Right. A police officer, for example, has certain powers and responsibilities that a civilian doesn't.
Exactly. It wouldn't be practical or even desirable to hold them to the same standards in every situation.
What are some other examples?
Another important exception is the concept of reservations.
Ah, yes, reservations. That's a topic that always generates a lot of debate.
It does, and it's a complex issue, but the key point here is that reservations which provide special benefits or quotas for historically disadvantaged groups are viewed as a valid exception to Article 14. They're seen as a tool for achieving social justice and creating a more level playing field.
So the argument is that in order to create genuine systematically disadvantaged in the past.
Exactly, and the courts have consistently upheld this view, recognizing that affirmative action is sometimes necessary to address historical injustices and create a more inclusive society.
I can see how that fits into the broader goal of achieving substantive equality. But I imagine there are also concerns about reservations, right?
Absolutely, there are valid concerns about whether reservations might perpetuate a sense of separateness or whether they might be misused. The implementation and scope of reservations are constantly being debated and refined. But the core principle is that they're seen as a necessary tool for achieving social justice and creating a more equitable society.
It sounds like a delicate balancing act.
It is, and there are other exceptions as well. For example, the Constitution allows for the granting of discretionary powers to the executive branch.
So this goes back to the idea of administrative discretion that we were talking about earlier.
Exactly. This discussion allows for flexibility in governance, but it also has the potential to be misused. That's why we have checks and balances like judicial review to ensure that this discretion isn't used in a way that's arbitrary or discriminatory.
It's all about accountability and ensuring that those in power are using their discretion responsibly.
Precisely. And then there are special laws for specific professions like the armed forces or medical professionals. These professions often have unique requirements and responsibilities that necessitate different rules and regulations.
Right. It wouldn't make sense to apply the same laws to a soldier on a battlefield as you would to a civilian.
Exactly. It's about tailoring laws to specific contexts while still upholding the fundamental principles of equality and fairness.
This is all starting to make so much more sense. I'm seeing how Article 14 is like a complex puzzle with all these different pieces that fit together to create a framework for a just and equitable society.
That's a great way to put it. It's about understanding the interplay between these different concepts, reasonable classification, non-arbitrariness exceptions, and how they all work together to ensure that equality isn't just a theoretical ideal, but a lived reality for all citizens.
Okay, before we move on, Are there any other important takeaways about these exceptions that we should highlight for our listeners?
There are a couple of specific areas that often cause confusion. One is the benefits enjoyed by members of parliament and the legislature.
Right, like immunity from certain legal proceedings.
Exactly. Some people argue that these benefits violate Article 14, but the courts have clarified that these are not arbitrary privileges, but rather mechanisms designed to ensure the smooth functioning of the legislature.
So it's about balancing individual rights with the need for effective and efficient governance.
Precisely, another area that often sparks debate is the establishment of special courts.
Like courts that specifically deal with cases related to corruption or terrorism.
Exactly. Critics argue that this creates a two-tiered justice system where different people are subject to different legal processes.
But the justification is that these are special cases that require a different approach.
Right. The courts have generally upheld the constitutionality of special courts, citing the doctrine of reasonable classification and the need for specialized expertise and expedited proceedings in these types of cases.
So even though it might look like a violation of Article 14 on the surface, there's a deeper rationale at play.
Exactly. And that's the key takeaway here. Exceptions to Article 14 aren't just random loopholes. They're carefully considered provisions designed to balance competing interests and ensure fairness in specific contexts.
I feel like I've gained a whole new appreciation for the complexities of Article 14. It's so much more than just a simple statement about equality. It's a dynamic principle that's constantly being interpreted and applied in new ways.
You've hit the nail on the head. It's a living, breathing principle that requires us to constantly think critically and analyze how it plays out in the real world.
This has been an incredible journey so far. I can't wait to see what other insights we uncover as we dive even deeper into the world of Article 14. Okay, so we've covered a lot of ground here, from just the basics of Article 14 to all this nuance of reasonable classification and non-arbitrariness,
Right.
and all these exceptions.
Yeah.
But what does all of this actually mean for our listeners out there?
Yeah.
The Indian law students who are just starting out on their legal journeys.
That's a great question. And I think the most important takeaway is that, Article 14, it's not just this abstract legal concept.
Right.
It's a powerful tool that you can use to analyze real-world situations, argue cases, and advocate for justice.
Yeah, it's like a key that unlocks this deeper understanding of the law and how it impacts people's lives.
Exactly as you encounter, cases in real-world scenarios, think critically. Through the lens of Article 14, look for instances where equality might be compromised and ask yourselves, can those instances be justified under the principles we've discussed?
Right.
Do they fall under one of the recognized exceptions, or do they point to potential areas where the law needs to be re-examined or even reformed?
So it's about constantly questioning and analyzing and pushing for a more just and equitable society.
Precisely. And remember, Article 14 is a living, breathing principle. It's constantly evolving through judicial interpretation.
Yeah.
What might have been considered a reasonable classification, a few decades ago, might not hold up today.
That makes sense. Society is constantly changing.
Right.
And the law needs to adapt to reflect those changes.
Exactly. So as law students, it's crucial for you to stay updated, on the latest case law and legal developments. Pay attention to how the courts are interpreting Article 14 in different contexts and how those interpretations are shaping our understanding of equality.
So it's like we're all part of this ongoing conversation about what equality means and how to achieve it.
I love that way of putting it. It's a conversation that requires us to engage with complex legal principles, but also with our own values and our vision for a just society.
So it's not just about, memorizing legal doctrines.
Right.
It's about developing a deep understanding of the principles behind them and how those principles can be applied to make a real difference in the world.
Exactly. And that's what makes studying law so fascinating and rewarding. You're not just learning about rules, you're learning how to use those rules to shape a more just and equitable future.
Well said. This has been an incredible deep dive into Article 14. I feel like I've learned so much, and I hope our listeners have too.
Absolutely. It's been a pleasure diving into this with you. And remember, this is just the beginning.
Yes.
There's a whole world of fascinating legal concepts out there waiting to be explored.
Thanks for tuning into LexTalks.
Of course.
Be sure to subscribe and stay notified for more deep dives into the fascinating world of Indian law.